In this country, the battle to have liberty and justice for all also apply to gay rights clearly began in the early 20th century, but many of us did not become aware of it until June 28, 1969, when patrons of the popular Stonewall Inn in New York's Greenwich Village fought back against ongoing police raids of their neighborhood bar. Stonewall is still considered a watershed moment of gay pride and has been commemorated since the 1970s with pride marches held every June across the United States. Following were incremental changes in law which began to decriminalize gay sex. The American Psychiatric Association removed homosexuality from its lists of mental illnesses. Laws were passed in some states outlawing discrimination based on sexuality, while other states were passing laws outlawing same-sex marriage. The first gay candidates were elected to local offices, but Harvey Milk is assassinated. President Clinton institutes a "don't ask, don't tell" policy and signs the Defense of Marriage Act, which defined marriage as between one man and one woman. Ellen DeGeneres comes out, and Matthew Shepard is murdered. The 21st century sees various states begin to allow same-sex marriage, with Massachusetts leading the way in 2004. On June 26, 2015, came the Supreme Court decision which recognized same-sex marriage as a federal right. I was already planning to officiate at Ruth's and Heather's wedding the next day on June 27th, but it was a pretty amazing thing to be able to quote both Jesus and Justice Kennedy in my wedding homily that day. I couldn't find any online readings of this decision, so you'll have to hear it from me today. I will read just some highlights from this decision. The entire decision can be found on the website links. Justice Kennedy writes for the majority when he writes, "The Constitution promises liberty to all within its reach, a liberty that includes certain specific rights that allow persons within a lawful realm to define and express their identity. The petitioners in these cases seek to find that liberty by marrying someone of the same sex and having their marriages deemed lawful on the same terms and conditions as marriages between persons of the opposite sex. The ancient origins of marriage confirm its centrality, but it has not stood in isolation from developments in law and society. The history of marriage is one of both continuity and change. That institution, even as confined to opposite-sex relations, has evolved over time. For example, marriage was once viewed as an arrangement by the couple's parents based on political, religious, and financial concerns. But by the time of the nation's founding, it was understood to be a voluntary contract between a man and a woman. As the role and status of women changed, the institution further evolved. Under the centuries-old doctrine of coverture, a married man and woman were treated by the state as a single, male-dominated legal entity. As women gained legal, political, and property rights, and as society began to understand that women have their own equal dignity, the law of coverture was abandoned. These and other developments in the institution of marriage over the past centuries were not mere superficial changes. Rather, they worked deep transformations in its structure, affecting aspects of marriage long viewed by many as essential. These new insights have strengthened, not weakened, the institution of marriage. Indeed, changed understandings of marriage are characteristic of a nation where new dimensions of freedom become apparent to new generations, often through perspectives that begin in pleas or protests and then are considered in the political sphere and the judicial process. The nature of injustice is that we may not always see it in our own times. The generations that wrote and ratified the Bill of Rights and the 14th Amendment did not presume to know the extent of freedom in all of its dimensions, and so they entrusted to future generations a charter protecting the right of all persons to enjoy liberty as we learn its meaning. When new insight reveals discord between the Constitution's central protections and a received legal stricture, a claim to liberty must be addressed. Justice Kennedy concludes the decision with these words, and this is what I quoted in that marriage I officiated at the day after this ruling came down. He writes, "No union is more profound than marriage, for it embodies the highest ideals of love, fidelity, devotion, sacrifice, and family. In forming a marital union, two people become something greater than once they were. As some of the petitioners in these cases demonstrate, marriage embodies a love that may endure even past death. It would misunderstand these men and women to say they disrespect the idea of marriage. Their plea is that they do respect it so deeply that they seek to find its fulfillment for themselves. Their hope is not to be condemned to live in loneliness, excluded from one of civilization's oldest institutions. They ask for equal dignity in the eyes of the law. The Constitution grants them that right."